sorry, but that's the way it goes.
No problem.
Okay, and we will reconvene. So I just kind of letting you know what my plans are. It depends on how fast my sugar crashes. And by the way, Lieutenant Rule, I have it. Okay, let's bring the witness back in.
Yes, Your Honor.
By the way, media guys, if I snap my finger, that means I think your camera's a little too high. You didn't have to move yours, just take it down. Ms. Brendel, we're back on the record, and I'm going to ask, keep your voice loud, okay?
Okay.
All right. Mr. Manley, you may proceed with cross, sir.
Thank you, Judge. Ma'am, can you tell me what I'm thinking?
Objection,
No,
question,
that's-
argumentative. Can you tell me
It's
what?
not argumentative.
Can you tell me what I'm thinking?
No.
I'm a lawyer. I can't tell what you're thinking, can I?
Correct.
Okay. In order to tell somebody or to convey what somebody's thinking, you have to either tell them or do something, don't you?
Correct.
Okay.
Objection, question, argumentative, and I can tell you why, Judge, if I could just make my record.
You may respond.
The reason why the question is argumentative about what's in somebody's mind is because, according to the case law, consent is to be judged from the victim's state of mind, not the defendant's state of mind. I'm going to cite the court, the case. So
I think you have those cases in that binder.
yes,
The black binder right
Yes.
here that I'm referring to.
Yes.
You came very well prepared.
yes,
You
and
know, Ms. Lindsay, in past practice with me, it's better off if I can read it myself.
okay,
So if you could just give me the case law.
okay.
And in continuing comments on that, I believe that Mr. Manley is getting to what her state of mind was, not anybody else's state of mind.
I want to get to what happened.
I understand that.
And there's, well, I'll wait, but
Yes,
there's,
wait, please.
I'll just wait.
Don't give me 85 pages. I
No,
don't
no,
have time to read
I'm just
85
giving
pages.
you, could I just put the case names on the, or could the court?
On the record, yes, certainly.
Okay.
Well, I'll wait.
Yes,
The
Doesn't
case
even.
names are People versus Hale, found at 142 Mish Act 451, and People versus Abdullah, 210 Mish Act Lexus 175, and 210 Westlaw 3604934.
I'm going to correct you on the site for just a second.
I'm sorry.
That's all right. It's just that I don't think Genesee County has Lexus, so I want to put the case sites on. She's giving me People versus Hale, reported at 142 Mishap, 451, which is a 1985 decision, and People versus Abdullah, it's a 2010 case, and I think the copy that she's given me does not have a site per se that we're used to. It just has a Westlaw number.
Yes.
However, it does not indicate that it's an unpublished opinion. So just give me a minute.
Judge, I don't even think that it's applicable at this point. I have not addressed Mr. Cleaves' state
I
of mind.
understand that. Okay. I'm going to read you the controlling thing, Mr. Manley,
Yes,
from
Judge.
the Abdullah case, which states, however, a victim's subjective state of mind determines whether consent was given, not the defendant's belief that there was consent. So she's arguing you cannot establish whatever it is you're trying to establish. I haven't gotten that far yet in your questioning. The consent factor based on whatever Mr. Cleaves was thinking, you must base it, I must base it on what the victim was thinking.
And I'm going to take it right through her
In
statement.
just a minute.
I don't know, is that a reported case?
I do not see...
I mean, we've had a number of cases that have been proffered as precedent that have not been.
I'm saying I don't see in the copy that she's given me that it's published. I only have a Westlaw site. And she gave the correct Westlaw site.
Mr. Muscat will know. Is it a published case?
You want me to look it up?
I'm
Would
sure
you
you had
please-
it already, looked it up.
Would you please look it up, see if it's been published so I can give the proper site?
What was the case again, Judge?
It's People versus Abdullah. It was decided September 16, 2010, and it's Westlaw, 210 Westlaw, 3604934.
3604934.
Yes,
Okay, Judge.
3604934.
Mr. Champagne indicates it's an unpublished case, Judge.
Unpublished, okay. People v. Hale is published because it gives me a Mishap site, and I gave it to you, 142. The People v. Hale case, which is an earlier case, 1985, talks about what the trial court was not required to give in terms of instruction to a jury, so I don't find it helpful at this point. The Abdullah case is unpublished, and but I do agree it's the victim's subjective state of mind that determines whether consent is given. And, you know, when it comes, please let me keep them. When it comes time for me to apply cases, and the only time that will come is either in an evidentiary matter or when I do the bind over, I'll have this case in front of me.
That's fine, Judge.
Okay?
I just, like I said, I think in the haste to object, there was a melding in an anticipation of my questions are going to be to her.
I'm not going to comment.
Thank you. May I move on?
Yes.
Ma'am, you never ever told Mr. Cleaves no that night in any physical encounter, did you?
I said I wanted to go home.
That doesn't answer my question. You said you
Objection, Your
never
Honor.
ever
No.
told-
Objection. He has to take the answer that she gave him. A witness is not forced to answer in any particular set of words that you want to force a witness to answer. That was the answer he got.
That was the answer he got. However, the question he asked required a yes or no answer, and I'm going to allow him to get a yes or no answer.
Ma'am, you never ever told the person that you know as Mateen no, did you?
No. Correct.
You never ever told him or pushed him away, screw this, get away from me, did you?
I did push him away.
Objection, asked and answer, Judge. That, once again, he asked the question. You never told him in any way physically. You let him ask again. He got the answer. Now he's got the answer. You can't keep asking the question. Ask and answer.
And I'm going to say at this point that I agree with her for this reason. She testified on direct, she pushed him away twice.
Hey, but I've got a thing where she says no.
Okay? I'm just telling you
Okay,
that's what
but
she
I mean,
said.
there's a reason they're objecting. They know.
I'm pretty sure.
Ma'am, you never told him, screw you, get away from me, did you?
Correct.
You made a point of saying that you've got a boyfriend, right?
Yes.
And you made a point of saying Mr. Cleaves was married, right?
Correct.
And you made this point in a hotel room, right?
Correct.
That you had gone in yourself, right?
Correct.
No one had pushed you, forced you into that hotel room, correct?
I was not told I was being taken to a motel room.
Well, let's go right to that. You're in the hotel room, right?
Correct.
And in fact, you told Detective Narian, this gentleman over here, that you were casually sipping on a drink in the hotel room, correct?
No, I took one sip of a drink Mr. Cleaves made me, and I put the drink
Mr. Cleaves
down.
made you. Okay, we're going to go through all this. So, you're a social worker?
Correct.
Okay. And you went to Central Michigan University?
Correct.
All right. And you're trained, right?
Yes.
And you counseled alleged victims of sexual assault, right?
Correct.
And you consider yourself a professional, correct?
Correct.
In fact, you have a LinkedIn page, correct, or you did?
Excuse me, just a minute. Mr. Manley, I understand the pace of cross-examination, and I'm
I'll
not
slow it
trying to
down.
break
I'll
it.
slow it down, Judge.
But I need to get her answers.
I'll slow it down.
I lost you at she went to CMU and she considered herself a professional. Where did it go from there?
As a professional, you had a LinkedIn page, correct?
Correct.
Which is not uncommon for young professionals, correct?
Correct.
And you in fact put on that LinkedIn page that you work for the Wayne County Child Sexual Abuse Task Force, did you not?
No, I did not.
Who did that?
It was part of a template that I created my resume on.
So there's a template. Can you show me that template? Where's that template?
Objection, Your Honor. Extrinsic impeachment on a collateral matter.
No, no, I'm going to
Goes
stop
to
you.
credibility.
I'm going to stop you because I have a question, and then I want you to address me with the answer to my question. One of the motions that Mr. Manley filed had to do with the fact that she was, what she had put on this LinkedIn page. If she didn't put it on there, it goes directly to a certain motion that we're all aware of. If she didn't put it on there, and there was, as she says, a template, would that not put to rest the one motion that I don't know has been decided in circuit court or not?
Well, the issue, the finding of the higher court was that Mr. Manley never established that the agency even existed. So whether, and that was the burden the judge on the higher court talked about. So whether it's on her page or not, does not address that issue. Mr. Manley's issue was establishing whether that agency ever existed, and the burden was on him to do that, which is what the higher court said. So once again, this is a non-issue in terms of the probable cause hearing. If he wishes to raise the issue again in the higher court, he is free to, but at this juncture, that motion has been taken care of.
May I respond?
Just a minute.
Okay.
Do you not think that this goes to my ability to judge the credibility of this witness?
Not under the Michigan Rules of Evidence. You have specifically 608 or 609. Specific instances are not used. So, no, I do not.
Give me just a moment, just a minute.
Yes, sir.
Did you say 608 and 609?
But I'm looking at 608 B.
It says specifically, specific instances of conduct of a witness, and that we're talking about the conduct of a witness here, what she did or did not put on a LinkedIn page. For purposes of attacking or supporting the witness's credibility, other than the conviction of a crime as in Rule 609, may not be proved by extrinsic evidence. They may, however, in the discretion of the court, if probative of truthfulness or untruthfulness, be inquired into on cross-examination of the witness concerning the witness character for truthfulness or untruthfulness, concerning the character for truthfulness or untruthfulness of another witness as to which character of the witness being cross-examined has testified. She hasn't testified as to the character of any other witness. But this certainly goes to the truthfulness or the untruthfulness of this witness. If she didn't put it on there, fine, then she didn't put it on there. But I want to know how it got on there. It goes to her truthfulness or untruthfulness, and it's within the discretion of the court, and I'm exercising that. The question may be asked.
Thank you. Ma'am, you said that you didn't put a LinkedIn
No,
entry.
Judge, excuse me, she answered the question, she said it got on there because of templates. So-
And then you objected, and he didn't get to ask about the template. I'm going to allow that.
Ma'am, you said that you did not put this on your page. Is that
Correct.
Is that correct?
Correct.
And you're a professional?
Correct.
And the people from Detroit asked you about, and today's your answer is that it's a template, that you had nothing to do with it?
I used a template to create my resume,
Which
correct.
would have had a false information on it?
Example information, correct?
Well, no, stop for there. You're sending out for your resume, correct?
Correct.
And this said Wayne County Child Sexual Abuse Task Force, correct?
Correct.
So if it's on your resume, and you're sending your resume out, correct?
Correct.
You would want people to believe that, correct?
Correct.
And that would be untruthful, correct?
Your Honor, I'm going to object.
No, I've already ruled on this.
But
You may make your record, but I've already
Okay.
ruled on this.
my objection was she said she used a template to create a resume. She never said that she put that in her resume, which he turned it around to in his questioning. The question was a mischaracterization of what she said.
The
She said-
LinkedIn page the court is very familiar with, and it is a resume, and job offers do go out based on it, and job matchings. I'm 67 years old, they're still trying to get me to work for companies. I'm going to allow this questioning to a certain extent, but your objection is on the record. You may proceed, Ms.
Ma'am, you never took that off, did you, until the Wayne County Prosecutor's Office told you to take it off, did you?
I was not aware it was on there and they didn't tell me to take it off.
Tell me, at some point in time, did the Wayne County Prosecutor's Office did they draft an affidavit for you?
Correct.
Did you sign that affidavit?
Correct.
Did you read it?
Yes.
Is it accurate?
Yes.
Can you tell me?
Wait a minute, Mr. Manley. What's fair is fair. You show Ms. Lindsay what you're going to show this witness.
You're a college graduate,
Correct.
you're a professional, correct?
Correct.
Your Honor, at this juncture, I'm going to object as to the relevancy of the affidavit because this goes to a collateral issue in terms of the motion to disqualify. The court has heard,
Go ahead.
the court has heard the answer as it relates to how it's on her LinkedIn page. So what the affidavit has to do, the affidavit that was drafted for the motion, why is that relevant in the probable cause hearing?
Do you want me to answer that?
You may respond, and then I will rule.
Thank you, Judge. It goes to truthfulness. This is a sworn statement which is in direct contradiction of what she says today. There's no mention of any template in it, that's why.
Just
Just a moment. Go ahead, respond. You have that opportunity.
just because nothing about the LinkedIn page is mentioned on that has nothing to do with anything. There's nothing on that page about the LinkedIn page.
Now I'm going to rule. I will not be interrupted. In the first motion, where you asked Mr. Manley for the Wayne County Prosecutor's Office to be disqualified, I said repeated times, I was not going to disqualify them, but that if I saw red flags, I might reconsider that decision. This, in my opinion, may, and I emphasize the word may, be the beginnings of a red flag. I'm going to allow you to ask about this affidavit, but before you do, I want you to show it to me to refresh my memory and what specific paragraph you're going to ask about. I probably have it in this file that's 18 inches thick, but I'm not going to look.
I'm going to direct for counsel in the court the whole affidavit, but primarily paragraph 7. Or what is it, 7?
Ms. Lindsay, Mr. Manley, would you approach?
Explain to me this Wayne County sexual task force, child sexual task force. What is it?
I'm not aware of a Wayne County Child Sexual Task Force.
But you saw it on your resume.
Objection, Your Honor, that's a LinkedIn page, it's separate.
Yeah, please refer to it as LinkedIn page.
But you used the LinkedIn page for your resume. You said that.
That was part of a resume template.
Okay. Where did you get the template?
I looked one up online.
So we define that right now. We define that.
Objection, Your Honor, that would call for her to speculate.
To the extent that it might be online right now would be speculation. She has no way of knowing that. But for the fact that she got it off the internet, that answer can come in.
Did you in fact inform the Wayne County Prosecutor's Office that this was just a template?
Objection, Your Honor, it's irrelevant.
It's very relevant as to how it got on the LinkedIn page and whether you knew about it or not.
Did you inform the Wayne County Prosecutor's Office when you were in Detroit? Do you remember being in Detroit with them?
Yes.
Do you remember having them draft an affidavit for you?
Yes.
Do you remember them telling you what to say?
They didn't tell me what to say.
Did you tell
I'm
them?
sorry, ma'am. I'm not hearing your answers.
They didn't tell me what to say.
You wrote out that affidavit, or did they write out that affidavit?
They asked me questions for the affidavit.
And you wrote it out, or did they write it out?
They wrote it out.
Okay. Where in the affidavit does it say anything about, because your answer today was very specific. I asked you about it, and you said it's a template, right?
Mm-hmm.
What's a
Correct.
template?
A building block for you to create your resume or create whatever document or you need.
And wasn't the whole reason that you went down to Detroit was to say whether or not you would work for that particular entity?
Correct.
Where did you tell them that it was just a template?
I told them that I was not aware of that task force.
That's not the same, it's not my question. Did you tell them in Detroit that this, like you told me, that it was just a template?
Yes,
So you told them, and they chose not to put it in the affidavit that you signed, right?
correct,
So you read the affidavit, right?
correct,
You signed it, right?
Correct.
And the first thing you told me today about that was just a template. It's just a form, a building block. But in the affidavit, you don't mention that at all, do you?
Objection, Your Honor, at this,
I can move on, Judge.
I want to allow her to put her objection on
Okay,
the
that's
record
fine.
if she wants.
since he's gonna move on.
Going to ask to answer. You, at a juncture here, went to Genesis Hospital, correct?
correct,
And you had an interview with a nurse, correct?
correct,
And I believe that nurse was a one by the name of Michelle Most, is that correct?
correct,
And you interacted with her, is that correct?
correct,
And your mom was there, is that correct?
correct,
And she asked you a series of questions, is that correct?
correct,
And one of the questions was if you would have had consensual sex within the previous 96 hours, is that
Your Honor,
correct?
I'm gonna object.
Why?
Under the statute I had cited to the court earlier, 75520, and they talked about that being specifically an issue that would be raised after the arraignment of the information.
I'm sorry, I didn't hear the last part.
Can we approach?
Yes, you may.
Yes, it is, but it talks about it has to be done within 2 days after the arraignment. The statute controls
I understand that. Here's